Major breaking news out of the United States District Court for the Western District of New York in front of Judge John Sinatra. A ruling in favor of the Second Amendment, specifically a challenge to New York's body armor ban can proceed. It can move forward because the plaintiffs have standing, which means that Letitia James and the other defendants in this New York State case have failed to knock the case out at the first stage involving standing. Let's break it down why this is a big win and why I think it bodes well for this case involving New York's ban on body armor. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the new law review article in the Georgetown Journal of Law and Public Policy entitled Dangerous But Not Unusual. Dangerous But Not Unusual. Mistakes Commonly Made by Courts in the Post-Bruin Litigation World. It's free. Click on it, print it, take a look at the copy, see what you think. It lays out in extreme detail how you go about analyzing Second Amendment cases. There's a lot of questions you posed over the years in the comments. I've tried to address a lot of those in this very long law review article, which I suspect will be read by law clerks, judges, lawyers, scholars, historians, and so on and so on. Anyone involved in the Second Amendment case or in the Second Amendment movement is probably going to take a look at this article at some point in the Georgetown Journal of Law and Public Policy associated with the Georgetown School of Law. All right, folks, so here's the story. Big win today. Remember how I taught you that you got to understand, to be a Second Amendment guru, you need to understand not only the meaning of the Second Amendment, the substantive law of the right to keep and bear arms as articulated and codified by our Second Amendment. You also have to have a little bit of understanding about procedure and process. The process by which a Second Amendment litigation or a Second Amendment legal challenge in a court goes womb to tomb through the court system. And as you know, in federal court, under Article 3 of the United States Constitution, which creates our federal courts, it creates the Constitution, Article 3 U.S. Constitution, there's a notion called standing. Specifically, federal courts only have jurisdiction to hear cases that are actual live cases or controversies. And one aspect of a case or controversy to make sure it's a real controversy and not just some hypothetical debate, for example, or where you need to give rise to an advisory opinion about something, there has to be a real controversy and real fight where a federal court can give you a remedy to address an injury you're suffering or have suffered. And that's where the notion of standing comes from, that a plaintiff has to have standing to sue a defendant in federal court, and standing in a nutshell means that that plaintiff has been hurt or will be hurt by virtue of something the defendant is doing, and that a court has the ability, has the institutional competence to enter some sort of an order or remedy that will remedy and address your injury, either through compensation or by prospective means, meaning going forward, they can stop the bad thing from happening in the future through what's known as a prospective remedy. So anyway, today, in the United States District Court for the Western District of New York, in front of Judge John Sinatra, who's issued some very favorable Second Amendment rulings on concealed carry law in the state of New York against the state of New York. In this case of Heater versus Letitia James, this is a lawsuit brought by several plaintiffs, including the Firearms Policy Coalition. And when they brought this lawsuit several months ago, this is what the president, Brandon Combs of the FPC, had to say about the case. Quote, New York's body armor ban shows that the state's commitment to authoritarianism has collapsed into absurdity, making it a crime to buy and use simple personal protective equipment. That's right, said Firearms Policy Coalition President Brandon Combs. New York's laws have gone so far off the deep end that it would be a surprise to exactly no one if Governor Hochul and her goons banned safety glasses next. The Firearms Policy Coalition looks forward to eliminating this unconstitutional law and teaching New York another lesson about constitutionally protected rights. That's powerful language there by the President Combs of the Firearms Policy Coalition. Now, if you look at this complaint in Heater, they specifically say that they have a fundamental right to have this body armor. In fact, I think that's accurate because if you look at the text of the Constitution, it says the right of the people to keep and bear arms shall not be infringed. If you look at the Supreme Court precedent, such as the Heller case in 2008, they define what an arm is. What are arms? Well, we know it's anything that can be used offensively or defensively, including body armor. It actually references that. So it seems to me, as a matter of Second Amendment text, body armor, protective armor, is indeed a form of arm textually in the text of the Second Amendment, the right of the people to keep and bear arms. And as you know, once the arms or the text of the Second Amendment is satisfied by the modern-day gun control law, meaning the plaintiff's activity that he wants to engage in is implicated by the text of the Second Amendment, or the gun control law does the same, the burden shifts to the government to justify their modern-day gun control law. Now here, what happened was Letitia James and the other defendants filed a motion to dismiss this lawsuit, claiming that the plaintiffs in this case lacked standing, and because they lacked standing in this case, the federal court, Judge John Sinatra in the Western District of New York, lacked jurisdiction to hear the case, because if you don't have standing to bring the case, there is no live case or controversy, and the text of Article 3 of the Constitution, which is the article that creates federal courts, references actual live cases or controversies. Without standing by the plaintiff, there's no case or controversy, and the case can be dismissed. But I'm happy to report great news that Judge Sinatra denied the motion to dismiss and said this case can go forward, specifically finding that the plaintiffs had standing to sue to challenge this body armor ban. In their complaint, the plaintiffs alleged the following, and this is what the judge had to say about the allegations and why, indeed, it was sufficient and is sufficient to show their standing here. Here's what Judge Sinatra had to write in the opinion today. Quote, "Here, plaintiffs have demonstrated injury in fact. They allege an intention to engage in a course of conduct arguably protected by the Second Amendment, but proscribed by New York law. Specifically, Heater, Brayman, and Wurtenberg intend to exercise their right to keep and bear body armor for lawful purposes. And because of challenged restrictions, they are unable to purchase body armor in New York. Plaintiffs also allege a credible threat of future enforcement. Specifically, they allege that the Attorney General is responsible for enforcing New York's restrictions on the sale of body armor imposed by the relevant law. And plaintiffs also point to the Attorney General's statements following enactment of the restrictions, which suggest that she intends to enforce the law." And they quote the Attorney General as follows, quote, "Today, New York has taken swift, comprehensive action to combat the gun violence epidemic. With this new package of gun laws, New York will continue to lead in imposing reasonable gun laws that keep your people safe, keep our people safe, and I urge other states to follow suit. The time for thoughts and prayers alone has long passed. Now is the time for action." And then she goes on to say, quote, "Make no mistake, this decision will not deter us from standing up to the gun lobby. I vow to use the full force of my office to protect New Yorkers and American families." So that's pretty clear that basically Letitia James in the state of New York has every intention to enforce this body armor ban, which I think, to be very specific, I think it's a ban on the ability to acquire or to buy some of this armor. But again, that's a nicety we don't need to worry about for the purpose of this video, because we're really laser focused on the fact that this legal challenge is allowed to go forward. And again, as a matter of text, I don't see how body armor is not an arm. And because that's the case, if you ban it, well, guess what? You're going right into the Heller-Bruin methodology, and I don't see how the government can show that, for example, body armor here is dangerous or unusual. It's certainly not dangerous. If anything, it's a safety device. And I don't see how it's unusual since, there's lots and lots of people wearing body armor all across the country. Just as a side note, right? I mean, they literally sell armored, if you will, right, body armor or whatever you want to call it, to children in the form of backpacks, right? They're bulletproof backpacks where they tell the kids to hold up the backpacks if they're being shot at. The effectiveness, I don't know. I can't speak to that. But the bottom line is, obviously, there is demand for this kind of protection if, heaven forbid, you ever find yourself in a situation where you're being attacked by a bad guy and you need to be able to save your life. Obviously, that's the point of body armor, which is why police officers, for example, wear it all the time, because you just never know when a bad guy is going to shoot at you, and you want to have some level of protection. So nevertheless, this is where we are. Judge John Sinatra is a good judge for the Second Amendment movement there in the Western New York. Why? Because he's handled a lot of Second Amendment cases. He's pretty familiar with this. He's read the case law. He's issued some favorable rulings in favor of the Second Amendment and the right to keep and bear arms. So I think Judge Sinatra gets it, that this is indeed a fundamental constitutional right, and the U.S. Supreme Court has told lower court judges like Judge Sinatra to take this seriously and don't roll over in the name of public safety and rule for the government just because they're the government. Don't ever do that. That's not how constitutional rights work, including the right to keep and bear arms of our Second Amendment. All right, folks, I will keep you informed as this case moves its way through the system, but this is very good news in favor of the Second Amendment, and we'll see what happens next. Make sure you follow me on X, by the way. I already have over 19,000 followers on X at 4 Boxes Diner, and make sure you subscribe to this channel, share it with your friends, like this video. We're trying to grow to get to 200,000 subscribers. I know we're very far behind in the Second Amendment community, but we're working hard to catch up. And I look forward to seeing you all again very soon here, the 4 Boxes Diner.
Orders up. Table 2A.